Good afternoon and hello. Thank you for joining us today in the next installment of our OG Energy Education series. My name is Brad McCamy, and today I'll be speaking concerning getting title out of defunct entities in North Dakota. As indicated, the focus of this presentation will be North Dakota. It's my goal to present a collection of scenarios where an ownership to title may have become stranded and how we may get title out of that stranded position. Generally, the complications discussed today will pertain to defects in conveyances, who can execute on behalf of these entities, and what to do when the subject entity may no longer have a formal existence. So a quick overview of what we'll be discussing today. The main topics we will look at are trusts, partnerships, and corporate succession. Additionally, we will touch upon interests that are subject to bankruptcy, ownership by minors, and unlocatable mineral owners. We'll look at examples and take sort of a nuts and bolts approach. So trusts are the first topic, and a trust is one way to control property ownership. A trust involves one party, the trustee, who manages property for the benefit of another, the beneficiary. So the parties to the trust are one, the settlor, being the person who creates the trust using their property. It may be easiest just to think about the settlor as the person who owned fee simple before the trust was created. Two, we have the trustee being the person who owns and manages the trust property. And three, the beneficiary being the person or persons designated by the settlor to receive the benefits of the trust property. The benefits from the trust generally consist of one, the income from the property during the existence of the trust, and two, the principal or property of the trust when the trust is terminated. So within the umbrella of trusts, we will take a look at examples involving omissions of either the trust name or the trustee's identity, and what happens when we have a trustee die. So the first example we'll look at are conveyances to a blind trust. So the record contains a conveyance to John Smith as trustee with no indication of the name of the trust. Is this a problem? Yes, the problem is the name of the trust is missing. So this is what we call a blind trust. The mineral deed names a trustee, but it does not identify the trust or disclose the names of the beneficiaries. So section 490912 of the North Dakota Century Code related to the interpretation of descriptive words notes, if any instrument relating to real or personal property shall be executed by or to any person as trustee, guardian, executor, administrator, or in any other representative capacity, and shall fail to identify clearly the beneficiary by name and the nature of the trust, the qualifying words in such instrument shall be treated as surplusage and as description only of the person by whom or to whom the instrument was created. As a result, the conveyance to John Smith as trustee is the equivalent of conveying the interest to John Smith individually. However, if the next instrument is from John Smith individually, no curative should be required. If the intention was for the trust to in fact own the interest, then the curative should consist of the following. Record either the trust agreement in the record or an affidavit which sets forth one, identification of the trust, and two, the individual's representative capacity. So now let's look at the opposite circumstances. In this example, consider a conveyance to the Smith Trust. This deed does not identify a trustee. Problem? Yes, no trustee identified. So section 47-1942.1 provides the conveyance is not voidable solely because the grantee in the conveyance is a trust rather than the trustee of the trust, or is an estate rather than the personal representative of the state, if the identity of the grantee is reasonably ascertainable from the conveyance or from the other information of public record, or from both. Therefore, if the identity of the grantee can be identified from the conveyance or from other information in public record, this conveyance will not be void. Therefore, if you encounter this situation where no trustee is identified, just like the previous slide, the curative that you should seek is either recording the trust agreement or an affidavit that sets forth the identification of the trust and the individual's representative capacity. So let's shift gears to look at what happens when a trustee is deceased. So in this example, John Smith was the trustee for the Smith Trust. However, John Smith has since passed away. So we should attempt to determine the identity of a surviving co-trustee, a successor trustee, or a replacement trustee. If John Smith was co-trustees with another individual or group of individuals, then section 591504 notes that the vacancy does not need to be filled. Further, section 591503 notes that in the event of a vacancy, the remaining co-trustee or co-trustees may act for the trust. If there are more than one remaining co-trustee, then they may act by majority decision. Thus, the death of a co-trustee doesn't immediately require that anything be placed of record. However, in the next conveyance from that trust, the surviving co-trustee or co-trustees should identify themselves as a, quote, surviving co-trustee, particularly if a trust required both co-trustees to act. Now let's look at if John Smith was the sole trustee. In this case, his death will again result in a vacancy. However, if he was the sole trustee, then we are left without a trustee. So section 591504, part 3, notes that the successor trustee should be determined in the following order. First, a vacancy must be filled by a person designated in the terms of the trust or appointed under the terms of the trust to act as the successor trustee. If the trustee if the trust agreement is silent, then we move on to the second order of priority, which requires that a vacancy be filled by a person appointed by unanimous agreement of the qualified beneficiaries. Now, if the qualified beneficiaries cannot agree, then finally, the vacancy may be filled by a person appointed by the court. Therefore, if we have a sole trustee situation where that sole trustee is deceased, then the trust agreement, if it's available, should be reviewed to determine the successor trustee. If it's not available, or if the beneficiaries cannot agree, or if they can agree, I should say, then we can obtain and record an affidavit which identifies the trust, the original trustee, and the successor trustee, and we can place that in the record to cure this situation and determine who that successor trustee is of record. If the trust agreement is silent and the beneficiaries cannot agree, then at that point, an interested person will need to petition the court to seek appointment of a new trustee for the trust. Finally, what if it is later discovered that the trust still owned property after it had been thought to have terminated? Well, theoretically, the trust, as long as it holds assets, theoretically, it shouldn't be able to terminate. So in the event that later assets are discovered, you should be able to obtain a conveyance from the trustee, or if this is something that was way in the past, a successor trustee. So if no trustee is available and that's a later discovered asset, then again, you might have to seek court assistance to help get that interest out of the trust. So from here, we're going to move along to the second main topic, partnerships. In this section of the presentation, we will focus on partnerships. Generally, a partnership is the association of two or more persons to carry on as co-owners of a business for profit. Further, the partnership is an entity distinct from the partnership's partners. Finally, property acquired by a partnership is property of the partnership and not of the partners individually. So here we will examine various conveyances to partners individually together and determine whether a partnership was formed or at least owns the interest of record. What is required when a partnership seeks to convey its interest? And what happens when partners change or when partners die? And then finally, we'll touch on the dissolving of a partnership and winding up a partnership. So we'll look at a series of conveyances, and on the face of them, they look somewhat similar. So first we'll look at a conveyance to John Smith. Then we'll look at a conveyance to John Smith with the label partner attached, conveyance to John Smith and Bob Jones, and then the same, but with a trade name attached. So the question with each of these grantees is the interest partnership property. So first, the conveyance to John Smith. Section 45-1404 provides that property acquired in the name of one or more of the partners without an indication in the instrument transferring title to the property of the person's capacity as a partner or the existence of a partnership will be presumed to be separate property. So in this case, the blank conveyance to John Smith will be deemed to have transferred the interest to John Smith individually. Moving along to the second example where the label partner is attached to John Smith's name. Part 1B of Section 45-1404 provides that if there is an indication in the instrument transferring title to the property of that person's capacity as a partner, then the result will be that the interest is partnership property. So in this example, we have that label partner attached. We don't have the identity of the partnership, but because it indicates his capacity, the statutes indicate this conveyance should be deemed partnership property. Okay, moving along and adding the second individual to the grant. So to John Smith and Bob Jones. What now? Title Standard 1302 indicates that John Smith and Bob Jones will be tenants in common as a result of this description. However, let's convey the interest again to John Smith and Bob Jones, but add a trade name. So in this case, John Smith and Bob Jones doing business as Oilfield Support Company. Looks very similar to the last conveyance, except this time we do have something of a description. However, despite the association doing business as Oilfield Support Company, Title Standard 1302 again indicates that John Smith and Bob Jones should be considered tenants in common. However, on the screen, you'll see reference to a statute there. And that statute provides a caveat to that title standard. So if the actual name of the partnership is indicated in the instrument transferring title to the property, then that property might be considered partnership property. If their partnership was Oilfield Support Partnership, that becomes a little bit muddy as to, do we have a partnership here or is that just a trade name? So other factors that could result in one of the prior examples being partnership property are if the property was purchased with partnership assets or the grantees share in the profits related to the interest. However, if that is the case, rarely will we have that information in the record or access to it. So that would likely be something that's determined off the record via judicial determination. And if we see it in the record, it'd probably be later on clarifying what this conveyance was meant to do. So now that we've looked at a few examples of conveyances to partners or to the partnership, we'll look at conveyancing by partnership. So in our first example, John Smith is a partner of SNS Partnership, and a conveyance by the partnership is later on executed by him, and he's as John Smith without indicating his capacity as partner. Will that be sufficient to transfer the partnership interests? Title Standard 1301 tells us that no, it will not. the standards states that will require that the partner signing the instrument must identify himself as a partner. So in this case, John Smith should have attached the label partner to his signature when he executed this conveyance. So in this case, while the grantee may have a claim to equitable title, despite the defective conveyance, in order to perfect that title in the grantee, proper curative would require executing and recording a corrective conveyance from S&S partnership, which is executed by John Smith and his partner. So the key takeaway with this example is that his capacity should be attached to his name in that signature block. So instead of a partnership this time, let's assume that S&S is a limited liability partnership. In this case, after hearing what we said in the last slide, John Smith signs his name as limited partner of S&S LLP. So will this be sufficient? The answer again is no. Section 45, 10.2, 45 notes that despite properly identifying himself as a limited partner, only a general partner may sign on behalf of the limited liability partnership. Therefore, John will need to go to the general partner, Todd Smith, and ask his general partner, Todd, to execute and record a new conveyance from the partnership. Okay, in this example, we'll discuss changes in membership of the partnership. So we're going to, again, talk about John and Todd Smith, partners for the subject partnership. If the records establishes that they are the partners of S&S partnership, but the next conveyance is executed by Ryan Jones as partner of S&S partnership, is that problematic? So in this case, we have an entirely new individual different from the ones that were established in record. The answer is actually no. Title Standard 1307 provides that when the conveyance by a partnership recites membership different from that appearing elsewhere in the record, we may nevertheless assume it is the same partnership and that the change in membership was in accordance with the provision of the partnership agreement. As a result, no action is required. If there were circumstances in the record that made you question what was going on, you could always request a copy of their partnership agreement to review it. However, based on that title standard, we wouldn't need that partnership agreement to be in the record. We could simply rely on that change of membership. So similar to changing of membership, we'll look at the death of a partner. So in this example, one of our partners has died. Does anything need to be placed in the record related to John Smith's death? Nothing is actually required. Partnership's interest in the property can simply be conveyed by the surviving partner. However, if John and Todd were the two partners of S&S partnership and both are now deceased, how does our result change? At this point, neither of them are alive to convey on behalf of the partnership. If that happens, Section 45-20-03 notes that the legal representative of the last surviving partner may wind up a partnership's business. Therefore, in this example, where Todd survived John, the appropriate curative would be to distribute the partnership by commencing a probate administration for the estate of the last surviving partner, so in this case being Todd, and then obtain and record a deed from the partnership, which is executed by the personal representative of the estate of that last surviving partner. All of that identified in the deed of distribution. So that was a bit of a mouthful. So just to repeat, after the death of the last surviving partner, partnership property may be conveyed by the personal representative of the last surviving partner. So what about the continued existence of a partnership? So in this final partnership example, let's assume S&S partnership properly acquired record title, but has not appeared in the record since. So let's say several decades have passed. In that case, can or should it be assumed that this partnership no longer exists? Despite the great length of time, no. Unless we have actual knowledge that the partnership has dissolved, the default assumption should be that the partnership continues to exist. What would cause dissolution of the partnership to occur? Section 4520.01 provides the following list of events, among others, that may trigger the dissolution of a partnership. So if one partner provides notice to the other of his intent to dissolve, that can trigger dissolution. If the undertaking for which the partnership was formed is now completed, such that there's no further purpose to the partnership, that could trigger the dissolving of the partnership. If the partnership's business or some other facet of that partnership is no longer lawful, then dissolution may be triggered. One of the partners can apply to the courts for a judicial determination, dissolving the partnership, or in the case of a transferable interest, if that partnership allows it, a new transferee could apply to have that partnership dissolved. So there's several ways in which the partnership can dissolve. So note though that even if dissolution has occurred, it's still not the final step. Instead, partnerships still must, quote, wind up the business. So winding up essentially is going to entail the procedure to distribute or liquidate any remaining property of the partnership, while also handling the payment of all debts, obligations, and or liabilities. So until that procedure is finished, the partnership still is in existence, and any partner that has not wrongfully disassociated itself from the partnership, or the legal representative of the last surviving partner in the event the original partners are deceased, any of those folks can be the ones to wind up partnership. So this will be our final slide on partnerships. And in this example, the subject partnership has dissolved and winding up is complete. However, as can be the case, it's discovered that the partnership still owns a real property interest in a tract they did not know about. Can the former partners execute on behalf of the entity after the partnership has been both dissolved and wound up? So in this case, unfortunately, they will not be able to. Section 4520.08 pertaining to omitted assets from that winding up procedure notes that title to assets remaining after winding up may be transferred by the district court. So if you come across an old partnership that's been dissolved, wound up, and then years later, it's discovered that they still have an interest, curative's most likely going to require that that partnership have an interested party petition the district court to transfer that interest. So the next main topic that we'll look at is corporate succession. In addition to conveying their interests, the record will often contain reorganizations of businesses, renamings or mergers, all kinds of changes to their structure, which may affect how their record ownership is titled. However, unfortunately for us, these successions don't always end up in the record. Therefore, in this topic, what we'll look at is who can execute on behalf of the corporate entity. In the event of succession, what needs to be placed in the record to establish that succession and complete the chain of title? And where can we find information related to mergers and other corporate succession? So first, we'll look at who can execute on behalf of the corporate entity. So in this first example, Smith & Jones Company acquires title A subsequent conveyance from the company is signed by Sam Smith, President. Is that sufficient? This is, in fact, sufficient. The statute provides that an officer of a corporation or a manager of a limited liability company is presumed to have the power and authority to execute any instrument on behalf of the entity. Therefore, if the wrong individual or if the individual in the wrong capacity signs, for example, in this case, if Sam Smith signed his name as a partner, a new corrective deed will be required to fix that conveyance. For this example, we'll look at variations in naming of that entity as they appear in the record. So if the record contains a variation in the name, will that be problematic? So here, Smith & Jones Company acquires title. A subsequent conveyance is executed by the Smith & Jones Company. So the answer is, it'll depend, but the title standards are generally pretty accepting for minor deviations. In this example, the first difference in the name is the inclusion of the word the. The second difference would be use of an ampersand instead of the word and. And finally, there's alternate use of the full word company versus the original abbreviation co. According to the title standards, none of the three differences described here would warrant curative. However, if, say, the entity designation company was swapped out for something different, like a partnership or LLC, that may require curative, as it is possible separate entities with the same base name could exist. So there could be a Smith & Jones Company and there could be a Smith & Jones LLP. So to avoid that confusion and to clarify the record, in that case, we may need to either correct that conveyance or obtain a stipulation from the parties to clear that issue up. What about name changes? So if an entity undergoes a name change, for example, here, Smith & Jones Company, will look at them again. If later on they execute a conveyance as SJ Services Co., will this be a problem? So yes, in isolation, this name change is problematic. If that's all we had in the record, we would need to do something to clarify that these are the same parties. Title Standard 1007 notes that a recitation in an instrument of record executed by an officer or counsel for that entity, explaining that the entity has changed its name, may be relied upon. Thus, in this example, ideally the grantor would be identified as SJ Services Company, formerly known as Smith & Jones Co. If we had that simple recital as to the identity of the grantor, that would be sufficient to establish that name change in the record. Now, if the conveyance has already been recorded so that we don't have that recital, what we could seek is an affidavit sworn to by an officer or counsel or the entity, which notes the name change and then record that affidavit. So the key there is just to get it in the record. The original entity has changed its name. That affidavit should be sworn to by an officer of the entity or counsel for that entity. So let's look at what if instead of changing its name, Smith & Jones Company subsequently merges with and into Anderson Oil LLC. So in this case, what do we need to see in the record? Title Standard 1007, again, will be our guide. It notes that a recitation in an instrument of record executed by an officer or counsel for the entity, explaining that the grantor is the successor of one or more previous entities, may be relied upon. Thus, in this example, ideally, the grantor would be identified as Anderson Oil LLC as successor by merger to Smith & Jones Company. We have that with a clear linkage to the original party, that would be sufficient. So similar to the last slide, if we don't have that in the record, then we should seek either a certificate of merger or, like the last slide, an affidavit sworn to by an officer or counsel for the entity, noting the chain of succession that we can then place in the record so as to complete that chain of title. Now, let's assume that the subject entity is going through the process of dissolution. What special requirements exist? If the dissolution is a voluntary proceeding, no special requirements will be needed. We can simply obtain a conveyance from that company and we are set. However, if the procedure is an involuntary dissolution, the record will be a little more involved. So in this case, what we'll need to see is a deed from the court-appointed receiver. And along with that deed, we'll need to see certified copies of the following to support that deed. The first support document will be the order which identifies and relates to the persons that are responsible for liquidating the entity's assets. The second order will be the order authorizing this particular sale. However, if the order that appoints the receiver provides that receiver with general authority to convey, then this second order won't be needed. And finally, a copy of the order which confirms this particular sale. So voluntary dissolution, no special requirements. If it's involuntary, we'll need to see more to support that conveyance. So moving further down the road, let's assume our subject entity has already been officially dissolved. However, it is discovered that that company still owns a mineral interest. So can authorized representatives, like a president, like a manager for an LLC, can they still execute on behalf of that entity? Unfortunately, no. Just as in the case of the partnerships, there's a similar statute. It notes that title to assets remaining after dissolution may be transferred by the district court. Therefore, if a entity has dissolved, an interested party should petition the court to assist in a transfer of that interest. So stepping away from examples, it's not uncommon for there to be gaps in the chain of title. So let's take a look at how we can go about filling those. In particular, in my practice, I see older leasehold chains were held by production leases. We tend to see a lot of gaps in that chain of title. So how can we go about locating information to establish who those successor entities are and why they're appearing in the record? And how can we make those connections? So what assets do we have available to look at? The first one are the county recorder's records. So let's start there. Online databases like NDRIN, which is the North Dakota Recorders Information Network, IDOC Market for counties like Williams County and Montreal County, or McKenzie County's Virtual Vault, all contain searchable databases. Thus, if we take our last owner of record, enter their name into that searchable database, and we don't provide any legal description, we're casting a pretty large net and we may find succession information from that entity, whether it's a conveyance by a successor that establishes that succession. It could be certificates of merger. Searching those databases is very helpful. So if your first search isn't successful, try broadening your search using less specificity. If there are several words as part of the entity's name, leave off one, cast a bigger net, see if you can find anything. The next option also relates to the county recorder's records. So any instruments filed for recording that do not include a legal description usually end up in the grantor grantee index. So if you encounter a gap in the chain of title, a search of the grantor grantee index could be fruitful. Next, every state has an entity that regulates corporations and other business structures that are registered in the state with a range of information that could be obtained regarding those business entities. That information could be formation dates for the entity, merger information, who the registered agent is, and address. So in the case of North Dakota, the Secretary of State manages this information, and the Secretary of State's website includes a business records search option. And there's a lot of information that can be found in there. Information about corporations, LLCs, limited partnerships, LLPs, fictitious names, partnerships, trade names, trademarks, even information on real estate investment trusts. So that option to check the state regulatory entities' records, you can find a lot. Finally, another great tool is the BLM's Corporate Name Change and Merger Index. It's an unofficial compilation of corporate name changes and mergers that have been filed with the BLM through the years. So what this index will indicate is if we're looking for Anderson Oil LLC, we'll go to the A's, see if we can find Anderson Oil, and if it's in there, it'll show who Anderson Oil LLC changed its name to or who it merged with, the state in which that information was originally filed, and a year. So a lot of good information can be found via that BLM Corporate Name Change and Merger Index. So with seeking out that information, I'd like to note these mergers are often recorded with no legal descriptions attached thereto. Common reasons why no legal description might be included with the recording. Maybe the party doesn't know where they own interest. They know they own them in the state. So they submit the document to the recorder, one county, several counties, and just get it in the record. Or in some cases, the amount of interests are extensive. So that party may want to simply avoid the huge cost related with indexing against numerous lands when with some of those lands, maybe that succession information is already record. Either way, if an instrument is submitted to the recorder without a legal description, that recorder is likely going to push back a little bit and ask, do you want to include a legal description for indexing purposes? If the filer doesn't, then the instrument will simply be recorded in that grantor-grantee index. This is significant because North Dakota is a tract indexing state. So by statute, recorders are required to maintain a tract index. The referenced Hansen case noted the following. The existence of a tract index has its primary focus upon tracts of land rather than upon grantors and grantees. And it makes the concept of a chain of title is developed in relation to the old grantor and grantee type index inapplicable. So in North Dakota, this tract index is the only practical index through which instruments on record can be located. Accordingly, failure to index an instrument in the tract index does not constitute such compliance with the recording laws that pertain to the matter of notice in order to give constructive notice. Therefore, while it's somewhat common practice to simply record and file those merger or succession documents in the grantor-grantee index, it's nevertheless recommended that legal descriptions be included when those documents are, just to make sure that those instruments get indexed against the right lands and get that succession information to the public that is looking at that tract. If that's not possible, for the reasons we noted earlier, or the parties simply choose not to index against numerous lands, options to consider are an affidavit could be recorded that simply references that curative document and then also describes the tract of land that you're concerned about, such that as to your tract, all of a sudden this succession document becomes a part of the record. Or in the chain of title for the next conveyance, you could include references to the succession and or instruments that may already be filed of record. That way, a certain document might not be indexed against your lands, but we can note it in the subsequent conveyance, and then the reader will be put on notice as to its existence and the contents of that document. So now we've reached the final section of the presentation titled Other. And here we're just going to quickly touch upon a couple of quick topics. So interests that are subject to bankruptcy, ownership by minors, and unlocatable mineral owners. So if you encounter an entity going through bankruptcy, Chapter 16 of the title standards should be your compass. There's a lot of guidance in there as to what can be accepted. And if you're an entity involved with that, review that standard, review that series of standards, because it'll tell you what all you need to have in the record. So the first example, bankruptcy is filed. So we have notice of that. Does anything need to be done? At this point in time, nothing. Just simply take notice that bankruptcy is ongoing and continue on. So what if we have a notice that the bankruptcy petition was filed after a conveyance by the record owner? Is this a problem? So 1602 provides that absent evidence of the contrary, the conveyance cannot be avoided by the bankruptcy trustee. So if that petition doesn't appear in the record until after that record owner conveys his interest, we're likely okay. Now, what if the conveyance by that debtor occurs after notice of that bankruptcy filing appears in the records? This is presumably problematic. Maybe. The next standard, 1603, provides that such a conveyance is allowed under certain circumstances. Some of these include if the bankruptcy case has already been dismissed. Okay, that one seems self-evident. If it's been dismissed, we don't have to worry about that bankruptcy. Another example would be if the debtor claims that property as being exempt, and in that bankruptcy proceeding, a bankruptcy trustee doesn't file an objection. In that case, such a conveyance may be all right. And a third example, if we have this conveyance and it is ratified or authorized by the bankruptcy court, that should be sufficient. So if a entity is going through bankruptcy, what should we generally look for if that interest will be conveyed? Generally, we want to see the following: a trustee's deed executed by the bankruptcy trustee, and the following support documents: verification that notice was served on debtor, relevant parties, verification that that property is not cash collateral, and finally, a certified copy of the order confirming the sale. So if you encounter a bankruptcy situation, follow the title standards. There's a lot of good information in there. As for minors, while a minor child can inherit interests in real property, transferring the interest from the child is another story. Section 1410.09 makes clear that a minor is prohibited from entering into contracts related to real property. Thus, one recommendation is to take advantage of the Uniform Transfers to Minors Act. What this act allows is for an adult to take custody of the child's property interest and manage that interest until the child reaches the age of majority. Thus, to take advantage of the act, the grant, instead of being to a child directly, it is to the particular adult as the custodian under the North Dakota Uniform Transfers to Minors Act. Note, however, that statute requires that under the North Dakota Uniform Transfers to Minors Act be included in the grantee's name. So if that language is omitted, the conveyance could be voidable, and therefore you may have to re-execute such a conveyance. So once the minor reaches majority, then the custodianship will terminate and the custodians should distribute the interest to that minor. Alternatively, If the property has already been transferred into the child's name, if you recall, that statute indicates that child can't enter into real property contracts. If the child already has title to that interest, then Chapter 30.129 pertains to the protection of property of minors. Those statutes can be utilized to petition the court for appointment of a conservator who could then act on behalf of that minor. So the final topic we'll look at today are unlocatable mineral owners. Sometimes a mineral owner simply disappears from the record. Even after a diligent search, they simply cannot be found. So we'll take a look at what the main options are that are available for the surface owner and for the operator. So what options are available to the surface owner? North Dakota, like several other states, has a Dormant Mineral Act. This is a process by which an owner of the surface of a tract is able to succeed to and acquire a several mineral interest to reconnect it with the surface, provided that certain requirements are met. The general theory behind this concept is a mineral owner or interest which has not been used for a specific unbroken period of years, 20 years, in effect might be deemed abandoned by the mineral owner so that it may be available for rejoinder with the surface by a surface owner. So whether a surface mineral owner can utilize this act and acquire dormant mineral interests depends on whether the interest has been used at any time within a specific prior unbroken period of 20 years. The nature of the use, it's indicated on the slide there. It's set out in the statutes. Surface owners required to give notice to the mineral owner of their intentions through this process. The mineral owner likewise has the opportunity to respond and show that the interest hasn't been in fact used or that they intend to preserve the interest. In North Dakota, we have a growing line of cases that has developed and have been decided by the North Dakota Supreme Court that discuss this act. If we see one of these actions in the record, do note that the courts require strict compliance with these statutes. Examine those documents carefully. Is these filings, they need to do everything those statutes ask. And if there's a small minor defect in their process, the entire thing will fall apart. So you see a dormant mineral action in the record, just be careful reviewing it, but know that that is an option for the surface owner to reunite mineral interests of unlocatable mineral owners. Next, what can the operator do about a unlocatable mineral owner? Well, the operator can utilize the chapter of the Century Code 3813.1 to form a trust for an unlocatable mineral owner. So the statute allows a person owning a mineral leasehold or royalty interest underlying a tract of land to petition the district court of the county in which that tract is located to declare a trust in favor of a missing person. The petitioner must show that a diligent but unsuccessful effort to locate that absent owner has been made, and that appointment of a trustee will be in the best interest of all owners. If the petitioner can meet those conditions, the court will then proceed to appoint the county treasurer as trustee for that unlocatable mineral interest. This is beneficial because it allows the county treasurer to execute leases on behalf of that interest, ratifications, division orders, other property-related instruments. Another benefit from the operator's perspective is after they pay production proceeds to the county treasurer in trust for that unlocatable mineral owner, it relieves the operator of further liability related to management of those monies. So it's a nice tool to remember for dealing with unlocatable mineral owners. We've reached the end of this presentation. We've covered a lot of issues, so hopefully this presentation can be referred to in the future. Hopefully, if you encounter something similar, you'll remember There was a presentation once that might have talked about something similar to this. So before we go, what are the takeaways? For trusts, make sure that both the trust and the trustee are identified in the record. Failure to do so may result in the interest being not owned in trust but instead by the individual owner. Additionally, if there's been a change in the identity of the trustees, simply note that as an adjective when identifying the trustees in the next conveyance. For example, a successor trustee, surviving co-trustee, that kind of thing. The partnerships, pay attention to how the partnership acquires property, and when it subsequently conveys that property, make sure you take a look at the signature block and see how they're executing it. If they're omitting signatures, if they're lacking those descriptive labels, there could be issues involved. And then for a defunct partnership, the last surviving partner or the personal representative of that last surviving partner's estate should be able to generally convey that partnership property. And then as for corporate succession, references to name changes or mergers and instruments of record go a long ways to helping fill gaps in the chain of title. If corporate succession records do get recorded, oftentimes they aren't indexed. So just keep in mind the various resources we talked about earlier that can help fill those gaps in the chain of title. So we've reached the conclusion. I'm going to quickly address accreditation. This program has been approved for 1 North Dakota CLE credit and 1 core certified professional landman credit. We are currently awaiting approval for Texas MCLE credit, AAPL credit, and CDOA core credit. We will provide the affidavit of attendance and further updates on the accreditation status in the follow-up email next week. Therefore, if you could please complete the post-event survey after the program has ended, let us know how we did. If you have suggestions, we value your feedback. Finally, if any questions arose during this presentation, feel free to send me an email. I always enjoy interacting and talking about difficult, complicated, funky title issues, so feel free to send me a message. Similarly, if a question about a related topic not addressed today came up, feel free to contact us. Thank you for your time and enjoy the rest of your afternoon.